Okay, thank you
All
very
right.
much.
Good afternoon, ladies and gentlemen. I'm Judge Michael Davis. You're all here because you've been arrested, and under the laws of the state of Florida, you have the right to see a neutral judge within 24 hours of your arrest. Today is not going to be your trial. I'm not going to be deciding guilt or innocence. What I will decide is whether or not there was probable cause to arrest you, and if there was, I'll set a reasonable bond in your case if it's applicable under the law. Now, you have the right to remain silent. Don't talk about the facts of your case today. Everything that you're saying is being recorded, and the state attorney's office is here with me in my courtroom. You also have the right to counsel. If you've hired a private attorney and they're not here, please let me know and I will contact them on your behalf. You also may utilize the office of the public defender. Mr. Romero is there with you in the main jail, and Mr. Opsal is here with me in my courtroom. All right, number one on the docket is Joseph Guerrero. And Mr. Guerrero, your attorney is here, sir.
Good morning, good afternoon, Your Honor. Steve Melnick on behalf of...
Come on up, Mr. Guerrero. Your attorney is there present.
All right, thank you, Mr. Melnick.
Your Honor, we would request ROR on this. You read the PC, he kind of grabbed her shirt to get away from her, and he still has a $500 bond on a 7-year-old misdemeanor cannabis charge.
Initial here, initial here.
All right, Mr. Linder, any priors?
Your Honor, the only thing I saw a prostitution-related offense, and it was like in the early 90s, I believe.
Okay. You know, Mr. Malik, does he have a place to stay separate and apart from this young woman?
He will. You'll stay separate from Heather until the charges are dropped, correct, Joseph? Nod your head.
Yeah.
Yes.
Your bond is $500 for your bond.
And advocate, have you had any contact with the victim?
Do you afford your bond? You have $500 in your pocket? You keep, are you on probation? No. You're on bond or pre-trial? Any cases?
All
Or
right.
felony?
This is what I'll do. I'm going to set a $1,000 bond on count one. I'll ROR count two, so it'll be a total $1,000 bond. I mean, if he wants to resolve the old capias, I'd offer withholding court costs on that.
Yes, we will, Your
Want
Honor.
to do
We'd
that?
like to.
All right, so why don't we resolve the cannabis charge?
Okay.
All right, so sir, my offer today is on the misdemeanor cannabis charge. If you want to plead no contest, I'll withhold adjudication, and you'll have a year to pay some court costs. And I think Mr. Melnick is recommending that you do that. Is that something that you'd be interested in? All right.
Yes.
So as to the cannabis charge, sir, I'm going to have you raise your right hand. Do you swear or affirm to tell the truth, the whole truth, nothing but the truth, so help you God?
Yes, I do.
All right, put your hand down and tell me your full name, please.
Okay.
Jose J. Guerrero.
All right, Mr. Guerrero, are you in charge of possession of cannabis? Do you wish to plead no contest to that offense, sir?
No contest, yes.
You understand by pleading no contest, you're giving up your right to have a trial.
Yes.
Are you under the influence today of any drugs, alcohol, or prescription medication that would make it difficult for you to understand me, sir?
No.
All right. I find your plea to be knowing, intelligent, and voluntary. I'm going to withhold adjudication, and I'm going to just have you give you a year to pay some court costs, $293, okay? All right.
Okay.
Thank you very much, Your
You
Honor.
got it. Now, sir, I'm just going to tell you, I know Mr. Melnick said, but I've got to say it for the record, you've got to stay 500 feet away from this young woman. You can't call, text, write, email, or try to find her on social media. Do you understand?
Yes.
All right, good luck to you. Thank you, Mr.
Thank
Melnick.
you, Your Honor.
Happy New Year.
Joseph, I'll see you tomorrow, okay, Jose?
Okay.
How we doing on Bill? How we doing on your case? Bill, how we doing on your case? I guess we need Ross.
Oh, okay. Thank you.
What? Oh, I got you. All right, when he comes back in. All right. And counsel, have you had enough time to talk to Mr. Jr.? All right, so what I'll do is, when he comes back in, I'll take Mr. Jones' case, and then we'll go ahead with your client, okay? All right. In that case, we're just going to keep rolling. Santos Martinez.
He's here present, main judge. He advised me he would like the services of a Spanish interpreter.
Sure, okay, we'll order one. All right, let's have a Spanish interpreter, yeah, please. All right. Lawrence Taylor.
Not that Lawrence Taylor.
Mr. Taylor, come on up, please.
All right, Mr. Taylor, good afternoon. You're charged with domestic battery by strangulation and false imprisonment. I'm going to find probable cause for these offenses. Advocate, have you had any contact with the victim?
No,
Your Honor.
All right, Mr. Linder, does he have any priors, please?
Your Honor, I'm showing in 2015 he was arrested for domestic violence battery. That was against the same alleged victim. The charge was dropped.
All right, Mr. Romero?
Yes, Judge. And speaking with Mr. Taylor, he's been residing in South Florida his whole life. He's currently employed at Aldi grocery store in stocking. He's been he makes about $12.50 an hour. He's been working for them for about 8 months. Your Honor, he did go away to school at Missouri. He received his AA degree in criminal justice. What he's doing now is saving back up to try and get his bachelor's degree. He does have a separate place to reside, separate and apart from the alleged victim. He intends on living with his mother. Your Honor, he has no money in the bank, no property. We'd be asking you to set a reasonable bond as to Mr. Taylor.
All righty. All right, Mr. Taylor, I'm going to set a $5,000 bond on count 1, a $2,500 bond on count 2. You're going to have no contact with the alleged victim. Don't call, text, write, email, or try to find her on social media. Stay at least 500 feet away. Do you understand that, sir?
Yes, sir.
All right, good luck to you. All right. Good?
Yeah, we can do Mr. Blass.
All right.
Last month.
Mr. Romero, I've got a few private attorneys here. I'm going to do Mr. Jellin's case. And I'm so sorry, I forgot your last name. I apologize. Tala? Miss Tala's case. And then I see Miss Small Williams in the back. We're going to do her case, and then we'll get back to the regular docket, okay? All right.
Can you hear me?
All right, folks. What's going on?
Please.
So here's the deal, Judge. This morning, Mr. Christopher Bless, apparently he's alleged to have committed a charge, DUI, serious bodily injury.
Okay.
The problem is he went to the hospital, he didn't know about it, so he's not in custody capias, and it's no bond because of the SBI aspect, obviously. So what happened was, him and his wife, who's standing right here, they went to court in Delray, and I guess he pled out a misdemeanor cannabis charges on crutches.
Okay.
And they notified him of the no bond from route, so he's either in the Palm Beach jail or en route to the Palm Beach jail.
Mhm.
He's going to be held up there for some time. The issue is he's on crutches, so the wife came running over with the medical records, and we are just trying to save him a week in the jail system because she's going to testify to his condition. Obviously, I don't know but she'll tell you all that. Mr. Weiner is agreeing to a bond, but it's kind of high, so I just wanted to see if the court was in a position to do something differently.
Here's my only problem. And I feel comfortable if you guys have spoken. Here's my only problem. I need to see some paperwork.
We have the report.
You have the paperwork.
Yeah.
Okay. If I
Ross has
can
the whole-
see the
it's a file
report.
case. It's a
All
file
right. It's a
case.
file case. If you have the report, if I can look it up, or if you can give me a copy.
Your Honor, it should be available on Odyssey.
On Odyssey. Okay.
My only issue is, and I had told Mr. Jellin this before, is
Judge, let me,
Yes.
assuming,
Thanks. That's easier.
assuming he in
Thank
fact is booked into the jail, I don't even know if you're under silent order, if the jail would even accept it. I think the proper procedure is he does have to be transported and booked into our jail here. And then once he's booked into our jail, then Your Honor would magistrate him. I don't even know if we could do this before he's even booked
Right.
into
I don't
our
know if
jail.
Palm Beach will accept it. Has he been in
take a
front of it?
teletype.
They
I
have
mean,
to
it's just like any other case.
it's
If
not
it had a
just
standard
here,
bond, if he was
fingerprint
able
him,
to,
right.
he would bond out. It's just
Might wanna
once
ask
the
the judge to
bond
wait
is
for
set,
confinement to
it'll be
get there.
teletyped to Palm Beach, and then he can post it.
And we might have to have confinement status to her also, because I don't know what their procedures are. Because if he's not physically booked into our jail, I don't know
Right.
how that would work.
You want
I
to
don't know
recall
where
it,
she
and I'll call Rukai?
Fine. She's coming back. All right. Sheila's coming back. She might be able to have some.
Thanks. He wants 22,000 in bonds, so that's $2,200 worth of bonds when in pretrial on house arrest, so you're going to have to testify. Is he working?
He got laid off because of his condition.
Judge, tell
They
him
thought he
directly.
was their liability.
Exactly.
I'm the only one that's working, and we have 2 children.
Okay, so just tell the, just common sense, just tell the judge.
There's a lot of that's what I'm saying. Yeah, there you go. Let me show you something. Oh, yeah.
Let me see if you have.
Yeah. Well, it's gonna clean up some. Read the charges. What problem you see? Finally,
Okay. All right, now the charges are DUI with serious bodily injury, no insurance, DUI unlawful blood, DUI with property damage, and driving on the wrong side.
Yeah, the actual file charges from the information are count 1 DUI SBI U balance, unlawful balance. 2 DUI serious bodily injury impairment. 3 and 4 DUI property damage. Obviously, when it's resolved, a bunch of those will be dropped, but that's where it stands right now.
Sheila, this is the situation we've got. This gentleman is incarcerated up in Palm Beach. He's going to be transported down here to Broward on these charges. What the state and Mr. Jellin are agreeing to is for me to set a bond today.
He's not in custody?
He's in custody in Palm Beach.
Palm Beach.
We can only deal with in custody people. If anything that needs to be done, definitely.
Why can't the judge set a bond and type it up to Palm Beach?
Is he in custody?
Yes.
He's in custody in Palm Beach, yeah.
You would have to go downtown.
Okay, but as long as the judge sets a bond, what do I have to do? That's all.
Right. They should be able to accept the order.
My only concern, Your Honor, is, and we haven't agreed on anything, is Mr. Jones not agreeing to my conditions of bond. One of my requests is pretrial. If there's any pretrial conditions the court's imposing, pretrial has to go interview in the jail. He's not here.
Right, that's correct.
Yeah.
That is correct.
Why, if you think pretrial is necessary, it doesn't appear to have a substantial record. The case today was a misdemeanor cannabis. What else was he ever? Sorry.
Well, I don't think we should even address it unless we can decide whether it can be addressed.
My position is, if you want to, you can set a bond. I'll figure out how to get it processed. I know it's not difficult. And then, but the question is whether you're comfortable setting a bond and without pretrial.
Judge, I think have one question.
Yeah, go.
Because he's not in custody, of course, I don't have any information. If he's in custody on a case warrant for these charges of targeting, then he has to see the division. It wouldn't even be a magistrate.
It's not in custody.
It's a not in custody?
Yes.
Not in custody, yeah.
He will come to magistrate.
Right.
But normally, that's just not protocol that.
No, I know. I understand the theory behind what Mr. Jellin is going to do. It's going to take a week or two for him to get transported. It makes sense. I need to hear more about, number one, the priors. I need to hear what the state is asking for, and then we can go from there. Because I'll make a decision about pretrial.
Mr. Bliss has a prior failure to appear from 1996 on a worthless check. He has a 1998 probation violation for misdemeanor cannabis. He was in pretrial diversion in Palm Beach on a possession of cannabis, which he pled out today to withholding court costs.
Okay.
The facts of this case, Mr. Bless's blood alcohol level 1 hour after the crash was 0.14. Another hour later it was 0.11. Another hour after that it was 0.09. It was also positive for THC. The victim suffered significant injuries. He was on his actual injuries here.
Driver was alleged to be in a Volkswagen and plowed into this gentleman driving to work early in the morning.
The victim was found lying on the ground next to his car. He had a 3-inch abrasion to his forehead. He had an open wound to his elbow. He had, this is the fire rescue records. From speaking with him, as well as his attorney, as well as the traffic homicide officer, he has significant injuries and he may never recover from them. Based on that, as well as the facts of the case, I was asking on counts 1 and 2, $10,000. Mm-hmm. Counts 3 and 4 already set at $1,000, so a total of $22,000. Special condition, pretrial level 2 with a TAD monitor, no driving, no alcohol, and no victim contact.
I don't have a copy, since he's on the docket, of his driving record. Do you?
I do have
his driving record.
Yes.
What does he do for a living, ma'am?
He just recently was laid off. He was working for a landscape company, but because of his condition, they felt like he was still liability.
Okay.
Your Honor, his license is currently disqualified for failing to file medical information.
Okay.
He has speeding in 2012 in South Carolina, careless driving in Palm Beach in 2015, an open container from 1991, as well as there were suspensions from 2011 that have been reinstated in South Carolina for failure to maintain insurance. So that's the extent of his history of his driving record.
And you have kids too? How many kids? How old?
13 and 14. I'm at 12 and 13. They feel
In normal circumstances, I would place him on pretrial release with the TAD monitor. It's a little bit of an unusual situation. He has some failures to appear. They're old.
He walked right into the courthouse today. And,
Right.
You know, he's going to be here. He's hired me.
This gentleman also had a pretty high blood alcohol level. What I would do is this. This is what I'm inclined to do. To secure his appearance, I would set a $15,000 bond in addition to the $2,000 bonds. So it would be a little bit higher. No alcohol or intoxicants. And you said his license is disqualified, right?
Correct, Your Honor. It's
So
currently
he would
disqualified.
not be permitted to drive an automobile, any kind of motor vehicle, motorcycle, nothing. Okay, if he wants to go to work, doctor's appointments, he's gonna have to Uber it, or you could drive him, something like that. Would you be able to make that monetary bond?
no. I would love to. School teacher. Make a lot of money. But I understand where you're coming from too, but I do want my husband too, so.
I mean, the other option is to wait the week, bring him back down here, and I'd feel more comfortable with a lower monetary bond if there were pretrial conditions in place, such as an ankle monitor, the alcohol monitor.
Yeah. So at this point, we're going to say thanks for the bond. Can you lower it anymore? The answer, I guess, is no.
Yeah, I'm more comfortable with.
What I would say is, that was rhetorical. I appreciate you trying, Judge. So what I would say is just see if you can raise it. Otherwise, we'll have to come back here, and then I'll have more supervision. But then the judge can do something about the monetary aspect.
They'll still set the case before me when he comes back from Palm Beach. So you'll see me again. And at that time.
Unless he bonds out.
Unless he bonds out, right. If you're able to make the monetary bond, sure. If he doesn't bond out, then Mr. Weiner will be back here, Mr. Jellin, you come back here, and we can have a different kind of conversation. And once he's back in Broward, I can put him on different kind of pretrial conditions. Okay? All right, so I'll set the $15,000 to $1,000 bonds on probable cause and go from there. No alcohol or intoxicants.
How are you splitting it, though? 75 and 75? I didn't know.
It's, yeah, we can do 75 and 75, that's fine. And no alcohol or intoxicants and no driving. Okay?
Right.
All right, Bill, this is yours.
Your Honor, so total is 17,000?
Yeah.
Okay. And then if Your Honor could just ask Mr. Jellin to advise his client, if he bonds out, what the conditions of bond that you set, since he's not going to be here to hear Your Honor's advisement.
Okay.
Got it.
All right, thank you.
And I'll do the short order, Your Honor.
For the bond?
All right,
Yeah.
thank you very much.
I thought they're not. Okay. All right. I'm used to it, so I gotta give you one. Thank you.
All right, Ms. Wall-Williams, thank you for coming. I told counsel I would do her case next, and then I will do Mr. Foreman, okay? You got my message this morning? Good, okay. All right, very good. Do you want to talk to the state for a few minutes? All right.
Yeah, see, he's
Yeah, come on up, please. I told you. All right, Philip Barsom?
Thank you, Your Honor, for agreeing to reset this afternoon.
Sure, no problem at all. All right, well, we have an additional charge here. Go, she can come through, Kia, if she wants. He was reset from the morning. All right, Mr. Barsom, so we have an additional charge here. It's failure to stop or remain in an accident involving death. I'm going to find probable cause for that charge. Mr. Weiner, counsel, you've had time to speak.
The judge is talking to me. Please move out of the way. Yes, Your Honor, I apologize.
Okay, no, it's fine.
Your Honor, I'm asking the court to find probable cause based on the new facts of the case. The new facts of the case indicate from speaking with witnesses involved in this case, including the passenger of the defendant's vehicle, that the defendant and his passenger began at 12 p.m. in Palm Beach. They started drinking at Brio's restaurant up in Palm Beach, where the defendant and his passenger work. They then went on to Tap 42 in Boca, and they ended at Diamond Dolls. They were drinking all day. They closed out the bill at about 8:34 p.m. The crash occurred at 8:50 p.m. There's also video surveillance at a gas station up in Boca at about 9:30 p.m. after the crash of the defendant walking into a gas station and speaking with the clerk. And based on the review of the video It's traffic homicide investigator Hirsch's opinion that just based on how he appears on video, that he was also impaired at that time as well. Based on all of this new information, as well as the now death of the victim, the state is asking for a $100,000 bond, with $50,000 of that to be fully collateralized. Level 1 pretrial with a TAD monitor, and the one with the RF part of that. No drinking, no driving. No drinking, no driving, no intoxicants, and the same any other conditions the court previously imposed on Tuesday, I believe.
Your Honor, first off, I'd like to say that these facts that the prosecutor is mentioning, they're all unsworn to. They're not in the probable cause affidavit. And Your Honor was aware that there was an allegation of drinking because it was in the probable cause affidavit. So Your Honor was aware of these facts that the prosecutor is mentioning when you initially set the bond 2 days ago. You also already ordered no alcohol. You ordered random drug testing. So what I'd ask the court to do is keep the bond as is. I think Mr. Weiner would agree that the victim is still technically not dead. I guess he's on life support, and so I don't know that much has changed other than the ad charge.
I thought he passed away.
Your Honor, he has been declared dead by 2 doctors.
Okay.
The only reason why he is currently on life support is just so they can harvest his organs, but he is in fact considered dead. The medical examiner has been called. There is a case number. They are handling that portion of the case. That was the last information I had from traffic homicide investigator Hirsch as of yesterday.
Let me say this, and I know this was not your intention. I was actually not aware of much of the information that is in this new probable cause affidavit. I was aware that there was an allegation of drinking, but in the original probable cause affidavit that I saw 2 days ago, there was no information, and there is now, about the witnesses, the passenger in the car, and the conversation that he had allegedly with the store clerk, and being covered in blood, and the statements that he made to the store clerk. Had I been aware of that 2 days ago, I think I would have set a different bond in different conditions. I'm aware of it now. And I'm very concerned.
Your Honor, he obviously has significant ties to the community. As I'm sure you remember, his 2 brothers were here supporting him. He does own property here. I just think to increase the bond by that much, given these new facts, I think it's unreasonable. I think, if Your Honor wants to increase the bond, I'd ask that you increase it by something like $20,000. And keep the same conditions, which are significant, that you've already placed on my client. You said no driving. That's what I'm asking the court to do today.
It's not an easy decision, because on the one hand we have this gentleman, and if I remember from 2 days ago, he does not have a significant history.
He has none, Your Honor.
He has no history. Not even really a driving record, much of a driving history. So he has lived, a clean life until now, for 28 years. He has very strong family ties. I met his 2 brothers yesterday. His parents are very supportive of him. And on the other side, we have a very young man who is now clinically dead, and a grieving family. And the statements that Mr. Varsa made allegedly, and the actions that he took allegedly after this incident that I'm now aware of, are concerning, very concerning. I'm going to set the bond on count 2 at $75,000. That'll have to be collateralized, so I will issue a NEVIA requirement. I'm going to alter the pretrial conditions to level 1. That's house arrest. He is not to imbibe any intoxicants, no illegal drugs, and absolutely no driving. Although, again, I've placed him on house arrest, so he should not be leaving his home. All right, this will require the full collateralization. I'm going to order that he have no contact with any of the witnesses or the passenger in his vehicle. All right, anything further?
No, Your Honor.
Your Honor, I just ask that you remove the no contact with the witnesses. They're not actual victims, or they were not injured. I don't understand the rationale there, Judge. I think it might interfere with my ability to prepare his defense, quite frankly.
Well, I'm not going to bar you from having any contact with the witnesses.
Okay.
You're fine. But I don't want him contacting the store clerk, for instance. I don't want him contacting the passenger that was in the vehicle. I have no problem if you do. I certainly wouldn't want to interfere with his defense, but that would have to go through you.
And people at my direction, you have no problem
That's
with?
fine. If you have an investigator, that's fine. This really is limited only to Mr. Varsom. Okay?
Okay.
All right. Thank you both very much.
Thank you, Your Honor.
Yes.
Are you keeping the passport in place?
Yeah, the passport surrender, right. The passport surrender is still in place.
And Judge, for clarification, the 75 will replace the former 30, so it will be a total of 75, correct?
Well, this is count 2. Count 1 was 30.
Would the court consider reducing the bond on count 1 in light of the high bond that has been placed on count 2?
I will set count 1 at 15. I'll make it a total of 100.
But you're gonna need a order because probable cause was already found for that.
Could the court instead decrease what you just ordered to avoid the?
That's fine. I'll make it 50,000, full collateral. Oh no, I want a total of 100. So this one needs to be 70, right? 70,000. This is why I went to law school. Bad math skills. All right, $70,000 bond and all the other requirements. All right, you. Yes. I'm. Right. All right. You've both been very professional, and I appreciate it. Good luck to you.
Thank you,
All
Your
right.
Honor.
Thank you. All right. Sylvia, you have a few minutes. I want to hear Miss Small Williams' case. All right. Thank you. I'll do the Spanish interpreter cases. All right.
Just 1 second.
Yes.
So I prepared an order for Mr. Wiener to review, and I spoke to confinement status. Essentially, if I can ask Madam Clerk just to certify this,
Yeah.
I'll send it to BSO Legal. They'll get it to warrants, and it'll be done in 2 seconds. So,
Fine.
Thank you.
All right. Come on up, Miss Small Williams. Brian Foreman.
Want to see if you had any involvement with anything.
How are you?
I'm doing fine, Your
Good.
Honor.
Good. Happy New Year.
Happy New Year. Valerie Small Williams on behalf of Mr. Foreman. Your Honor, I received the second half of the PC. I guess you didn't realize it was 2-page. The Assistant State Attorney was kind enough to show me the first half.
Good.
Because my part didn't indicate when these allegations were from.
Right.
Your Honor, I've been dealing with several cases, and we entered an agreement with the state that the 16 case that I guess still had a no contact order, I don't think I was even aware of that because I wasn't given the no contact order. I was given a no contact order on a misdemeanor battery that was no prox.
Right, in front of Judge
So,
McHugh.
and I'm not alleging anything, I'm just making a statement. So I never shared that with Mr. Foreman. I can tell you we're set for mediation on a dissolution of marriage next week.
Okay.
I can tell you that the wife has been in contact with my office. I can tell you she's represented by another member of the bar here in Broward County. Mr. Foreman has resided here for well over 15 years. He is a professional. I don't want to pronounce what he does from this stop. I don't have a problem approaching you, telling you what he does for a living.
Okay.
Judge, I'm asking the court to set a bond, a low bond. His parents reside in the state of California. They're elderly. They retained my services on the dissolution. He retained my services on the criminal matter.
Okay.
I believe these allegations stems from some monetary issues. And I'm not pleading any breaches on behalf of Mr. Foreman, but I can tell you if there were breaches on the other side. and I'm trying not to go into details on it because of the position I'm in today.
No, I understand. You're in a funny position because there's an open divorce and
There's
yeah.
and there's an agreement that I fought with the state that they obliged that he entered, and that agreement is in jeopardy. And that agreement was the basis for him to retain his job. And like I said, he's a professional. If I may approach, I'll tell the court what he. I just asked the court not to say it out.
No, I won't. Okay? I won't. I'm just looking. It's on the arrest.
Not on the booking, on the arrest, the PC affidavit on top.
Oh, I see. Okay.
Judge, because the state previously no-prossed fleeing and eluding out of the city of Coral Spring based on negotiation. The second part of the negotiation was on April 3rd of this year, that the state will no-pross the violation of a previous contact order. But like I just indicated to the court, wasn't present when the no-contact order was entered on the fleeing and eluding. Knew about the no contact order on the misdemeanor that was already no-pross.
Right.
There's other things in the PC that the assistant state attorney was kind enough to go over with me that concerns me. But Judge, I can tell you if he remains in custody, everything is done. He has 2 young boys with the alleged victim. And I can tell you that there's culpability on her part, major culpability with this.
Do they have, since you're representing them also on the dissolution, they have a visitation schedule worked out?
Judge, yes. That's just with that order sitting there that I wasn't aware of. My concern, Your Honor, is this. We are scheduled for mediation. If the court permits, I believe it's next week. He was in my office as early as this week, going over documentation with me to have everything to her attorney to work out that settlement agreement and to make sure everything was lifted. She indicated to the state attorney when the misdemeanor was no-pross that she had no problem with contact, yet the other order remained out there that I wasn't aware of.
Right.
Okay? If I knew that order was out there, Judge, I would have scheduled a mediation.
Right.
Or anything.
Right.
So.
What's your position,
Your Honor,
Mr.
well, first, a couple things I want to clear up. I'm going to start with where the history of these issues, these cases start from. Mr. Foreman was first arrested for a battery against the alleged victim.
Right.
A no contact order was issued.
And I will say, actually, so from this morning when I was looking at the paperwork, I could see it was a confusing case because there's multiple cases going on. I took a look on Odyssey during the lunch break because I wanted to see the procedural history of the case. It went from Judge McHugh, now Judge Robinson, and now we have this.
He was then arrested for fleeing and eluding law enforcement, DUI, violating the no contact order when he allegedly went to her home, banging on her door, and resisting without violence. We have no-pross the fleeing and eluding, and there was a no-contact order issued again on that case. And the copy of the no-contact order is attached to the paperwork before the court.
I saw, yeah.
If you look at the findings that Judge Gottlieb signed, it was stamped, no victim contact. There's nothing before the court at this point to indicate that he was not advised by the court not to have contact, Your Honor. And now we're here again today with him violating another no-contact order. I don't know if the court, I can tell you, that the alleged victim has applied and obtained not only a temporary injunction order of protection against Mr. Foreman, but also one on behalf of the children, Your Honor. And I did review the petition that was done on behalf of the children. The allegations are concerning. I don't know if Your Honor had an opportunity to review that. I don't know if you were even aware to review that. But basically, we're now here because there's a second time he's alleged to not follow a court's order not to have contact with this woman.
Here's the thing, sir, Mr. Foreman. I gotta talk to you directly. You made a good decision. You hired a good attorney. Okay? She's very capable, and she's going to represent your interests in your divorce case. She's going to represent your interests in this case. Okay? If she tells me that she didn't know there wasn't a no contact order in the case, in your felony case before Judge Robinson, I believe her. You cannot have any contact with this young woman.
That's
You gotta stay
understood, sir.
500 feet away from her at least. You cannot call, you cannot text, you cannot write, you cannot email her, you can't find her on social media. If there's an open no contact, injunction as to your minor children, then you've got to abide by that order too. Now he's on pre-trial.
Understand.
That's the case with Judge Robinson. Okay. What are the conditions? Standard?
Judge, I wrote it up because the prosecutor didn't know how to handle it. Here's the thing, Judge Robinson stayed out of this. This was a negotiation between the state, Assistant State Attorney Ross Weiner and myself, and Ashley, who was the third in Judge Robinson division. Judge Robinson was like, I could have, and just to make a representation, Judge, because my reputation means a lot to me in this building, I could have walked out of the courtroom that day without doing the pretrial order. She said it wasn't needed to be done, and I said, no, I'm not going to mess you over like that. Let me do the order. And I wrote up the order. When I got the misdemeanor battery case, no props. The contact order, to the best of my knowledge, was done. I was not aware that attached to the felony DWLS case number, there was a no contact order. In fact, the alleged victim represented to the Assistant State Attorney, Candace, about not going forward and working out time sharing with the children, and that's to work out to get rid of the misdemeanor battery. Because not only was I in front of Judge Michael Robinson's felony division, I at the same time handled the first degree misdemeanor battery in front of Judge McHugh. So I had those two cases, and because of his profession, it was urgent that I get rid of the felony. In the state of Florida, in that profession, you cannot have a felony, not even with a withhold.
Right.
So all of that came into place. If this court orders him no contact, even if she initiates the contact that she's tired of the children come and get them, and then I can support that, what I just made on this record. There will be no contact. I'm asking this court, and I'm not trying to litigate it here, Your Honor. I'm asking this court for a bond. He has a job. He's on the original 20-day suspension. I don't know how this is going to impact that job. That is something that he's going to have to deal with. I dealt with already. And I'm asking this court for a reasonable bond. I can tell you that 20-day suspension that he's on is he's not getting paid for it. He's had 3 surgeries on his hand, and I think the other one was on his foot since July alone. And we were set to dissolve this marriage through mediated settlement agreement next week with Scott Strata out of Coral Springs on the dissolution case. And that case is in front of Judge Lopez. And the injunction on that case was set aside. So that's the confusion with this.
Is there an open injunction that you saw?
I know. Well, she applied for one within the past few days, and the temporary were granted.
And that one hasn't been served yet, if I'm not mistaken.
There's no allegation that he's violated an injunction,
right?
Your Honor.
Well, so how to instruct if there's a temporary injunction that Judge Kaplan has granted.
I don't know exactly which judge has granted it, but I see.
Oh, is it right? That's right. You said
It wasn't followed through on it. I went to the hearing. The hearing was canceled, and that's the last of that.
All right.
With respect, no, there are. Excuse me. You said before you weren't aware there was no contact order. I don't think you're aware about this temporary injunction. So if I can, then you'll be aware. There were temporary injunctions that were granted within the past few days, Your Honor. One, where she is the protected party, and 2, where the children are the protected party. Now, Your Honor,
Give the case number any chance. I want to.
Your Honor, if you go to the civil and family section, and you do a search on Mr. Foreman's name, and they'll come up as the most recent. That way I don't have to give you each case number individually. And
all right, that makes sense. The only, The reason I'm doing that, by the way, I'm not inclined to revoke his pretrial in Judge
Then-
Robinson's division. I am inclined to extend that pretrial in this
Well-
case. Well,
Your Honor, what I'm going to be asking for then is a GPS monitor, and if I can reply to a few things. One, his job keeps getting brought up, but really, how much of a deterrent is possibly losing his job? When he's out on one case, the battery, he gets arrested on DUI and violating the no contact order. His job apparently was not losing his job was apparently not a deterrent. The deal that Ms. Wall Williams keeps talking about, I spoke with Mr. Weiner before court today. The deal is very simple. No new law offenses. No new law offenses, and we will not refile the fleeing and eluding law enforcement. He wasn't able to do that. And all he had to do was follow a court's order and just have no contact with this woman. And he couldn't do it. He wouldn't do it. And you can see in the evidence, this officer saw screenshots and voicemails that he left for her against the court's order. So I don't know how much confidence the court can have at this point that he will not continue to attempt to make contact. And again, Your Honor, and I would encourage the court to look at the petition that is filed on behalf of the children, because it is concerning. There's an allegation of use of alcohol, which would violate his release conditions. Now, he couldn't have been tested. It happened, I believe, on Christmas Day or around Christmas. Pre-trial wasn't open. By the time they were open, any alcohol would have been out of his system. Your Honor, here, the first one, Your Honor, is DVC, when you're ready.
go ahead.
DVCE-17-9.
That's the whole case number? Oh, there it is. Okay.
It's one of the first ones of the new year, I guess. And that's the one that Ms. Foreman filed on her own behalf.
Temporary injunction was granted on 1/3/17, signed by Judge
Yeah, that's why I saw that you can't tell from the signature.
Not Judge Kaplan's signature. It might have been Judge Murphy, but it was granted on the 3rd. And you said there's no appeal?
Yes, Your Honor, and that one is DVCE-17-12.
Your Honor, if I may inquire,
Sure.
does your system show service? I'm asking the court.
And I can tell you, they haven't been served. They were just filed, and I'm not alleging that he violated an injunction.
Same judge, yeah, they granted the on behalf of the children. No, they have not. Neither one of them has been served.
I would ask the court, though, to consider the petition.
No, I looked. I saw the petition.
Okay.
All right.
And I mean, I think if someone keeps and it's within the court's discretion whether to revoke and hold them or not. I understand. As far as bond on new matters, I think it only is logical if someone keeps taking up new offenses, the conditions have to be more strict to give the court confidence that your orders will be complied with.
Ms. Small-Williams is going to drop you like a rock if you, and I hate to speak for her, but I think I know her well enough to
They're
know.
more than accurate. I can't wait for them to get out.
She's going to drop you like a rock if you have contact with this woman and these children, and that's not going to be your only consequence, I can promise you that. And I'm the only judge, except for on the weekends, that hears first appearance hearings, so you'll be right back in front of me. I'm going to set a $5,000 bond. I'm going to set pretrial release conditions. I think what I'm going to order is a TAD monitor.
What is the TAD, Your Honor?
That's like a scram.
Your Honor, here's the issue with the scram, and we went through this. He cannot get on that truck that he works on with that device. That device is susceptible to water, which is a key part of what he does.
Judge, I'm sorry if there's consequences,
Judge.
but excuse me, how many times can his job
All right,
affect?
he's going to have to do random testing.
Well, Your Honor, I just want to know, I believe he was doing that anyways.
Judge, we have no problem continuing the random testing that he has to do.
I mean,
Yes, Your Honor.
All right, we'll continue with that. 2 times a week random.
So he's gonna be on standard.
He'll be on standard pretrial.
Judge, I would like him, can I approach with the prosecutor?
Sure. All right. You're also going to have a substance abuse evaluation, sir. Drugs and alcohol within 48 hours if possible. Yep. Sir, I could not be more clear about this. And this is all on video. Everything is being recorded. Until a judge tells you otherwise, not your wife, not your kids, nobody. Until a judge tells you otherwise, you cannot have any contact of any kind with your wife. Also, I'm telling you that there is a temporary injunction as to your children that a circuit court judge has granted. Right now it's just temporary, but right now you cannot have any contact with your children. Until a judge tells you otherwise, that is going to stand. If you do, you're going to be immediately rearrested. And I can promise you it's not going to be a $5,000 bond. You've got to stay at least 500 feet away from your wife. You cannot call, you cannot text, you cannot write, you can't email, you got to try and find them on Facebook. Nothing. Do you understand that?
Yes, Your Honor.
All right. Thank you both. You've both done a great job. Good luck.
Thank you.
Thank you, Your Honor, appreciate it.
All right. Sylvia, thank you for being patient. Yes, we have a standard pretrial. Yeah.
Wait, Your Honor, one other thing, just Valerie, I just want to put on the record that nothing I did here, I have not, the state has not formally sought a revocation, Your Honor.
I know.
And I just want to put that on the record, that'll be up to the assigned prosecutor in front of Judge Robinson.
I understand. Ms. Small-Williams understands that. She knows. All right. All right, very good. Thank you, everyone. Good job. All right, Mr. Martinez, Santos Martinez.
Señor Martínez.
He's here present.
All righty. Santos Martinez is back on the domestic docket. All right, Mr. Martinez.
Page two of the docket.
Page 2. I'm Judge Davis.
Yo soy el juez Davis, señor Martínez.
Sylvia, do you swear or affirm to accurately translate from Spanish to English to accomplish the best of your ability?
Yes, I do, Silvia Orozco.
Very good, thank you. Sir, you've been charged with domestic violence battery.
La acusación que tiene es agresión y violencia doméstica.
Domestic battery by strangulation.
Agresión y violencia doméstica mediante una estrangulación.
And abuse of a child without great bodily harm.
Y también el gran daño físico.
I'm going to find probable cause for these offenses.
Encuentro que sí existe la causa probable de estas ofensas.
I'm going to ask the state's victim advocate if she's had any contact with the victim.
Voy a preguntarle a la fiscalía si ha tenido contacto con la víctima, la defensora de víctimas. Sí, ella estaba preocupada, quería saber cuál era el resultado de esto y no dijo nada acerca de su seguridad.
No, Judge.
¿Hay antecedentes? No, juez.
All right, Mr. Romero.
Señor Martínez. Romero.
Yes,
No,
Judge.
I'm
And
asking
speaking with
Señor Romero.
Mr. Martinez, he's been residing in South Florida for the past 19 years. He's currently employed. He works at Primo's Pizza. He's been working for the same company for 4 years.
Lleva 4 años
He
con
makes
la misma empresa.
$15 an hour.
Gana
He is a
tantos
cook.
dólares a la hora.
He has no money in the bank, no property.
Tiene dinero en el banco, no tiene propiedad.
He does have a separate place to reside other than with the alleged victim.
Sí tiene un lugar donde vivir aparte de la víctima.
He will be living with his cousin, Judge.
Va a
We'd
vivir
ask you to
con su
set a
primo.
reasonable bond as to Mr. Martinez.
All right, sir. I'm gonna set a $1,500 bond on count 1.
1.500 de fianza en el cargo 1,
$5,000 bond on count 2,
5.000 cargo número 2,
and a $2,500 bond on count 3.
2.500 de fianza en el cargo número 3.
You're to have no contact with the alleged victims in the case,
Puede tener contacto con las supuestas víctimas de este caso,
your wife and your child.
su esposa y su menor de edad.
You're going to stay 500 feet away.
Debe mantenerse 500 pies alejados de ellos.
Don't call,
No puede llamar,
text,
mandar texto,
write,
escribir,
email,
mandar
or
correos
try to find them on social media.
electrónicos ni buscarle en los medios sociales.
Mr. Linder, the PC doesn't indicate whether or not Child Protective Services was contacted.
Your Honor, I called already and made the report.
All right, thank
Yo
you
ya
very
hice el
much.
reporte con el Servicio de Protección a los Niños.
All right, good luck, sir.
Buena suerte, señor.
Alcohol. Alcohol. Sorry. All right, anyone else need the Spanish interpreter?
Yes. What's your name? ¿Qué es su nombre? He's on the second look docket, Mr. Floriano Matias Pablo.
Okay, all right, great, I see. Traffic case.
2,500.
All right. Sir, you've been charged with DUI,
La acusación que tiene es conducir ebrio,
DUI with property damage,
de daño a la propiedad,
DUI with breath alcohol above .15,
más de 1.5 en el alcoholímetro,
operating without a valid
conducir
license,
sin licencia válida,
leaving the scene of an accident with property damage,
del lugar de la escena del accidente con daño a la propiedad
and failure to use due care.
y no utilizó el cuidado debido.
Let's see. All right, you're being held on a $2,500 total bond.
2.500 total fianza.
This? Matthias Pablo.
Is it that he's verified? Is that why they put it back on? Patrice? This is Mr. He's on the second look docket. His name is.
Your Honor, we sent someone to the residence. They actually went out again. No one was there again. Has not yet been verified, Your Honor. Our hope was that we would have had some information from this report.
Okay.
But when we did, someone went there this afternoon at about 1. Still no one is there. Mr. Matias Pablo.
What are his priors?
I'm not showing anything, Your Honor.
Nothing.
The court wants to sign a pending verification.
Yeah, that's what I'm gonna do.
Someone is gonna go back.
All right, Mr. Matias Pablo.
Señor Pablo Matías,
I'm gonna keep the bonds in place, but sign an order
voy a mantener las fianzas en su lugar, las dejo así, pero firmo una orden
that once your residence is verified,
que una vez que se verifique la residencia, la dirección suya,
you can be on pre-trial release.
se le puede poner a usted en libertad previa al juicio, es un programa.
You'll have to do a substance abuse evaluation
Tiene que hacer una evaluación de lo que es abuso de sustancias
and random testing.
y tiene que dejarse someterse a pruebas al azar.
You won't be allowed to drink any alcohol
Se le permite beber alcohol
or use any narcotics.
o utilizar ninguna clase de narcótico.
Who do you live with, sir?
¿Con quién vive usted, señor? ¿Con quién vive?
Un amigo.
With a friend.
A friend.
Okay. Do you know what he does for work, for a living?
¿Y usted sabe ese amigo qué hace, en qué trabaja?
Who signs the order?
Roofing.
Roofing?
Roofing.
Does he usually work during the day hours or does he work during the evening hours? Do you
Él
know?
trabaja durante las horas del día, trabaja en la noche. ¿A qué horas trabaja él?
De día.
During the day. Han dejado una nota allí en la puerta de la casa
Venga,
para que se
sidebar.
pongan.
All right, never mind. Forget what I said.
Olvídese lo que dije, no se preocupe.
I'm going to release you today to standard pretrial.
Lo voy a dejar a usted en libertad hoy día, hoy mismo, a lo que se llama estándar prejuicio, antes del juicio.
You're going to have to report to them by tomorrow. Mr. Romero is going to give you a map.
Tiene hasta el día de mañana para reportarse en ese lugar. El abogado Romero le va a dar un mapa.
He's going to tell you where to go.
Le va a decir dónde debe ir.
It's a little late in the day now, so you're going to have to report by tomorrow.
Un poco tarde ya hoy en el día, repórtese mañana a primera hora.
And you're going to have to follow all the conditions that we already talked about.
Hay que cumplir con todas las condiciones de las cuales ya hablamos.
Do you understand that? Does that make sense?
¿Me entendió eso? ¿Tiene sentido lo que le estoy diciendo?
Sí.
Yes.
All right, good luck to you, sir. Take
Buena
care.
suerte, señor.
Let me explain it to him.
Thank you. All right. I think that's it, Sylvia, but let me just make sure. All right.
Thank you, Judge.
Oh, sure. Anyone else needed the Spanish interpreter before I let her go?
Not at Maine, Judge.
All right. Thank you, Sylvia. Have a nice day. All right. Sharon Allison.
Sharon. Miss Allison, come on up, please.
All right, Miss Allison, you're charged with driving under the influence of alcohol or drugs and improper stopping on the sidewalk. I'm going to find probable cause for that offense, ma'am. I'll set bond on count 1 at $500, and there's no monetary charge on count 2.
Judge, in speaking with Miss Allison, she's advised me she's been residing in South Florida her whole life. She is working in security. She's been employed with the same company for 2 years, making $10 an hour. Your Honor, she lives in Fort Lauderdale in an apartment. She's been living in the same location for 2 years. Her rent is about $675. She has 4 kids. They're all grown, living in our community. Unfortunately, she doesn't have their phone numbers memorized. She doesn't have her phone and property. I do not believe, she advised me she's a registered voter. I believe she advised me that she may have been arrested 30 years ago, but since that, she has a clean record. I asked you if you would consider an ROR on Miss Allison's behalf.
No priors, right, Mr. Leonard?
I have to check.
She advised, oh.
I know what she advised.
This is Sharon Allison.
Okay.
Anything?
From what I can see, it's got looks like I don't know if you have her record. It looks like she has a lot of traffic.
A lot of traffic stuff. She did have a DUI refusal back in '93.
Yeah, that ended up being she was found not guilty.
Right. And the PIP cancellation, a few of those. It's not.
I just saw a lot of traffic cases up there. The clerk system. That's all.
There is more on the clerk system than there is on the sheet.
I got. Yeah, I don't know what's on. That's why I asked if you have a record. I don't know what's there. And some just speeding, not necessarily traffic criminal offenses.
All right. That's all right. I'm comfortable with an ROR in this case. You're going to be released on your own recognizance, ma'am. You're going to have to come back and face these charges. You cannot consume any alcohol or other intoxicants, no narcotics, and you're going to have to come back and answer to these charges. Do you understand?
Yes.
All right, good luck to you.
Thank you, Judge.
Sure. Afsana Ahmed?
Mr. Ahmed, oh, I've been advised she bonded.
Bonded? Okay, I'll find probable cause. Jillian Sloan.
Miss Sloan, come on. Oh, I've been advised she's in regular court.
Oh, it's probably that shelter. Yeah, all right. So we will reset this Friday p.m. Okay. Yeah, tomorrow afternoon. Kathleen Morriso.
Miss Morriso, come on up, please.
All right, ma'am. You're charged with petty theft in the first degree and possession of a blank or fictitious driver's license. I'm going to find probable cause for that offense. Bond on count 2 be $1,000. There's no charge for count 1.
Judge, and speaking with Miss Morriso. Oh, I'm sorry.
You don't want to. You don't have to. But if there's anything you want to tell me, you can talk to me off the record if you want. Yeah. Yeah. All right. She got some family members here. They want to talk to me off the record. So just a second. All right. Kathleen, your mom has spoken to a bondsman, and she's working on having your bond posted. It's $1,000, and your mother understands what to do, okay?
Okay.
All right. All right. Good luck to you. Take care of yourself. Yeah. Yeah. Oh, yeah. Yeah. There you go. All right. Corey is it Casto?
Casto, she's at North Broward.
Okay.
Your Honor.
Yes.
What we are asking, we understand that she has no civil life plans at this time.
Okay.
She spoke with her boyfriend.
Okay.
Claims that the client is in desperate need of some drug treatment. We are in contact with a facility that may or may not take her, and so we're not saying yes at this point. So we're asking the court to reset her for tomorrow afternoon.
Is there anything that I can do can I speak to that?
Talk with the halfway house and see if they'll take her, if there's a bed, what needs to be done, and so forth.
Do you want me to speak to the halfway house?
We already talked to them.
Oh, okay. All right.
They're aware of her.
If you need me,
She's already been scheduled for a second look tomorrow.
She's already scheduled for a second look?
No, I'm saying we don't have to reset it then.
No, Judge, so ma'am, what's going on is pretrial release has contacted a halfway house. Maybe we could get you over there, okay? Your boyfriend's not bonding you out.
But I'll see you tomorrow, and we'll see what happens. And if I have to call this halfway house myself, perhaps. Well, hopefully they'll have a bed. If they don't have a bed tomorrow, then we'll see where to go from there. Okay? So it'll be $1,000 on count 1 and 2, and $100 on count 3. I find probable cause, and we will reset your case for tomorrow. It'll be on the second look docket. Okay, I'll see you tomorrow afternoon.
Okay, why did he say why he's not gonna bond me out?
That's a different story, ma'am. It's not a question I can answer.
Ma'am,
for
we were
him.
trying to get you treatment, okay? We're trying to get you into a halfway house. Just wait a day.
All right, we'll see you. I'll see you tomorrow, Miss Casto.
Yeah, I was supposed to go to detox today.
All right, come on. Yeah. Warren Samuel.
Mr. Samuel, come on up, please.
All right, Mr. Samuel, good afternoon. You're charged with violating your felony probation. You're going to see Judge Bober on January 10th at 9. Until then, you'll be held, without bond. All right? Good luck to you, sir.
Yes, sir. Thank you. Daryl Fitch, come on up, please.
All right, Mr. Fitch, you have 2 counts of violating your felony probation. Count 1 is a no bond hold. On count 2, your judge has ordered a $5,000 bond. You have 2 court dates coming up. January 11th at 9:45. That's Division FV. I think that's Cohen. Is that Judge Cohen? FV is Judge Cohen. You'll see Judge Cohen on the 11th. That's a no bond hold. And then you'll see Judge Rothschild. Oh, it's a $6,000 bond. I said 5. I meant 6. Sorry. You'll see Judge Rothschild on January 9th at 8:30 a.m. to address that charge. Okay, so 2 different judges, 2 different violations of probation. The jail will bring you down to see both of them. Okay?
Yes, sir.
All right. Good luck. Avery Ramsey.
Mr. Ramsey, come on up. Judge, Mr. Ramsey would like to know if you have information already indicated someone posted his bond.
All right, looks like your bond was posted, sir, so it's a $1,000 bond. I'll find probable cause and be out today. Good luck.
Okay, someone's posted it.
Claude Charles.
Mr. Charles, come on up, please.
Okay. Got it. All right, Mr. Charles, you're charged with a burglary of an unoccupied structure. I'm going to find probable cause for that offense. Does he have any prior?
He doesn't have anything in Broward. I don't know if he has elsewhere.
Do you have anything, Patrice? Embezzlement of an auto. That's a new one to me. Okay. I didn't know you could embezzle an auto. Yeah.
In 2015, there's no disposition. Apparently, he went to court on that case, October of 2016.
The embezzlement of the auto.
Yes.
My understanding is, according to Mr. Charles, that case was dropped.
Okay. All right, sir. All right, Mr. Romero, what would you like to tell me?
In speaking with Mr. Charles, he's been residing in South Florida his whole life. He is 27 years old. At this point, he is looking for employment. He was previously working at an election shop, making about $10 an hour, canvassing. Your Honor, he has no money in the bank, no property. Financially, he has no sort of resources to post bond. He's asking you if you could consider an ROR.
All right, sir. I'm going to set a $2,500 bond. You're to have no contact with the business owner in this case. Stay 500 feet away. Don't call, text, write, email, or try to find them on social media. Good luck to you. Jose Coleman.
Mr.
2,500, yeah.
Your Honor, this is a down file from an armed burglary to a burglary of an occupied dwelling.
Okay.
He's being held on felony murder for his other count. You may want to just bring up the case number.
Yeah. What was the bond?
Originally, it was armed burglary, so it was no bond.
Oh, right.
Judge, I've been advised that Mr. Coleman has retained Thomas Moore. He declined the services of public defender.
Okay. All right. I can call Mr. Moore. Do you have this? If someone can give me a number, please. Thomas, is it Morse or Moore?
It's Morse.
Oh, Morse. Okay. Oh yeah, he's here somewhere. Oh, that's fine. He was probably leaving.
Well, the issue is, Judge. Wait, let me see. Hold on one second. Okay.
Is this the young man? Now, oh, okay. I remember the case now. There was a felony murder charge.
Yeah, that's been filed.
That's been filed. All right, I remember the case. How you doing, Jose?
I'm all right.
I forget. Did I order life skills classes for you?
Yeah, but they said I couldn't go because of the felony murder.
Because of the felony. Okay. All right. All right. I hear you. All right. Well, listen. I'm gonna set a. I'm going to set a $20,000 bond in this case on count 2, the burglary. No contact with the victim. Don't call, text, write, email, or try to find him on social media. Stay 500 feet away, okay?
Okay. What is they? I don't understand what's going on with the felony murder thing.
Nothing's happening with the felony murder. That stays the same. What happened is you were charged with burglary of an occupied dwelling, armed. Under the law, I can hold you no bond on that. They've changed that to burglary of a dwelling without the component of without you having a weapon. So it's a different charge you're allowed to have under the law. I'm allowed to give you a bond. You're still being held no bond on the felony murder charge.
All right.
All right. You're going to see your judge. I think it's Judge Singal soon, and your attorney will be there with you. Like I said to you the first time, I hope you're thinking about things. Did they let you have books in there? You have access to the library?
Yeah.
All right, that's good. I hope you're taking advantage of it. And read some books and think about things, all right? All right, good luck. Take care of yourself.
When the court did.
All right. Anthony Seda?
Conti, Your Honor.
All right. All right, Mr. Seda, good afternoon. You're charged with attempted burglary of an unoccupied conveyance. It's a change of charge?
Yes.
From burglary of an occupied conveyance. All right, what's the bond?
Was it? Hold on one second.
3?
Sheila, there were 3 different burglaries originally. Do you know which one this was the change of charge to? I think it's
$1,000 bond.
Well, good call. That's what it was originally.
2,500, 1,000 on counts 1 and 2. It's down file.
All right.
Yeah, it was 1,000 originally.
All right, $1,000 bond will remain. And so you have a status hearing coming up January 9th at 8:30 a.m. Okay? In front of Judge Bailey. Good luck. How about Jeffrey Johnson?
Mr. Johnson, I've been advised as a reset judge.
Okay. Tomorrow afternoon.
Wait, on who?
Johnson? Jeffrey Johnson?
Oops, okay.
Friday afternoon.
And we have the only one left here at Maine would be Mr. What's your name? Mr. Barry Leonard Prince Jr.
Okay.
He's set for a 30-day ROR motion.
30-day, yep. Ryan Coughlin on the regular docket? I didn't have any paper unless, did anybody else have? No.
There you go.
You know if Mr. Prince's charge has been filed?
So I'm checking right now. Yes, information's been filed.
All right, so the charges in your case have been filed, so the motion is denied for today. You're going to see your division judge soon for an arraignment. Good luck to you. That was Mr. Prince, Barry Prince. All right, thank you, Mr. Romero. I'll see you tomorrow.
See you all tomorrow.
All righty. Second look. All right, Conti, it looks like you're the only ones left. Who have you got? Oh, I'm sorry. I meant Paul Ryan. I meant Paul Ryan. Sorry.
Well, Your Honor, I got Winch.
Which, what is it? White. Okay, White, Mr. White, okay. Is this a 30-day?
Yes.
No, it's denied.
It's been filed.
All right, sir, your motion for release is denied. The case has been filed, and you'll be brought before your division judge soon for an arraignment. Good luck. Anyone else there at Paul Ryan?
That's it, Your Honor. Nobody else.
Okay. That was Mr. White.
At North Broward, there was a Donta Clark. He's a medical reset.
The Donta Clark is a med reset. And how about Sean Rich? Sean Rich, and then there was also Donald Hornback.
Well, wait, Your Honor,
Yeah.
we can't just medically reset Dr. Clark. This is a motion that was filed that's time sensitive in nature.
Oh, it's a 30-day?
Yes.
Was it
That's what I'm checking right now. I mean, I'm being told it was filed. Dante Clark. Yeah, that was filed.
Well, I'm going to grant them. I'm going to deny the motion then. Public defender will let him know. That's on Donta Clark. And what about Sean Rich?
1 moment, Your Honor. Well, Foz, this one's really up to you. One was filed. You know what? It's a moot issue, Your Honor. You can grant the motion on the 13748. I'm sorry, on 12350.
Yeah.
We declined the leaving the scene of an accident with injury.
Okay.
And filed a no valid DL. I don't believe that there's a bond attached to it. If there is, it's 25. But we did file 12259.
All right, so we'll do two separate orders. 12259 is denied. 12350 is granted.
Yes.
Just the only concern I have is because this is an important motion for the defendants, and I know we already know what happened, but I'd rather have them present so somebody could tell them what happened. It's not that
Did they just forget to bring him up, or is it a medical thing?
Well,
Or?
I know I could tell you, Mr. Clark was unable to medically come up.
No, Clark.
I don't know.
What about Sean Rich?
I don't know. I don't know why Mr. Rich is not there.
All right.
I have a question on Sean.
Yeah.
On, say, what the hell are you doing? That's all you're 12259. What did you say about?
That was filed. 12350 was not filed.
Yes, that's correct.
12350. He was not.
If they want to bring him up, I'll wait a few minutes if you want to call over to the jail.
Well, did you get the filing instructions to? It doesn't really matter. I mean, you're gonna whether the motion's denied or granted. Was there a bond attached to the operating without on that charge? Because here, 1 moment. Let me just check this real quick.
We were holding him. We were holding on 14133 CF10A.
I don't even have that.
I know.
No info.
That's not even on the
And
docket.
then they filed it on the misdemeanor and transferred the case to 11591 for battery and resist.
He's being held on 122.
He's being held in 16.
Yeah, you know what, Judge? 12350 should be denied because I'm looking at BSO Pigs. He's not being held on it. It's a moot issue. He's not. If you look at BSO Pigs and confirming what Sheila just said, he's not being held on those charges.
No.
I'm saying 12350. He's not being held on.
350, no.
Yeah. So whether we filed it or not doesn't really matter. It was
Not in custody on it.
as far as the system is concerned. No. 12259. No, that's another matter.
That was filed.
That was filed.
All right, so Phyllis, we're going to need a new order for this case. Denied. Yeah, denied.
Yeah, we only really need 225.
And if you want to call I'll go cyber for a minute. back on the record. All right, I'll reset Mr. Rich to tomorrow. Sorry, all your hard work is a little wasted now, Phyllis. I'm going to get rid of these orders. I'll reset them for tomorrow afternoon. Both.
Well, you could just keep the order with the paperwork.
Right, you can keep the orders. Keep the orders with the paperwork. Don't file them yet. And I'll see him tomorrow afternoon. All right. And there was a Donald Hornback on the second look of misdemeanors. It's an MO. Yeah, we did him. He was at Paul Ryan. Denied. It was at 38. It was denied. Hornback, let's reset him for tomorrow if he's still in custody. All right, guys. Thanks a lot. Have a good afternoon, everybody.